Okay, so today I'm going to start with Guernsey and the United Kingdom, and Liz will be back in the afternoon, which we told her starts at 1 o'clock. And so we'll then hopefully be in a position to move on to finish off the remaining sort of domestic, purely domestic Guernsey material, which I'm sure we'll all say she was an immense help yesterday, and particularly to me. It's quite possible that because I closed the lid on the computer without doing parts 5, 6, and 7 on this sheet in front, that there is no recording of yesterday. It's quite possible. I'll make sure that that doesn't happen today, and I'll record at the end of each half day. So Guernsey and the United Kingdom. This part is one of the only part today. This and the international relations part, which is attached to it necessarily. It's the only part where I've been able to use to a large extent, the notes from Jersey, which have been produced and been used for some time there, because to a very large extent, the issues are exactly the same. So when we get to the actual cases, obviously the most recent main case is a Sark case. If you go back to the principal 19th century cases, most of them were Jersey cases and one of them was a Guernsey case. It actually really doesn't matter, except for one minor point, one minor statute. It doesn't really matter whether you're talking about Guernsey or Jersey in this particular area, because the constitutional relationship is the same. So the way we're going to go through this is to start with the royal charters and the deep magic of the relationship with the Crown and the Kings of England. We then move on to what's one of the key documents in all of this, which is the Kilbrandon Report. Kilbrandon Report wasn't particularly a report on the Channel Islands. It was a general royal commission into the Constitution, which was done at a time when membership of the EEC was being considered. Those of you who are old enough, the EEC is the European Economic Community, might remember. And also the European Convention on Human Rights was beginning to take greater effect, as there was a right of individual petition to Strasbourg. So these were constitutionally difficult times, and there's Northern Ireland as well to throw into the mix. So it considered everything, and a part of its considerations were the Channel Islands. And as you'll see, one of the difficulties is that although this was essentially just a royal commission, which had its eyes largely cast elsewhere, it's almost taken as holy writ as far as the UK is concerned, as regards what the conventional constitutional position is. We then move on to the what's a really good question for essays, which is legislative power of Westminster over Jersey. You're now getting into good law, good, nice principled law, interesting stuff which you can try and get under the skin of, get to know jurisprudentially. It's also actually not just an academics topic. It's not just there because we quite like to discuss how many angels you can get on the head of the pin and that sort of thing. It actually became quite interesting this year. You have to hand down. Do you have any spare? Yeah, they're all handed out. It's 12 to 13. Because early this year, as many of you know from the papers, the UK did indeed come close to legislating for the Crown dependencies without consent. And this was very much a opposition and backbench driven affair, which to a large extent, almost you could say that all bets are off as regards constitutional conventions, because constitutional conventions really rely on the understanding at the level of the high officials informing the ministers that no, this is a no-go zone. When it's backbenchers running amok to try and prove a point, when it's to some extent getting caught up in the internal conservative politics that flow from the breakdown of their own party discipline, it becomes a very, very difficult position. So some of the things that we're saying represents essentially Jersey and Guernsey's constitutional defence against those sort of attempts, which just about held good last year. But if you read the comments from the likes of Andrew Mitchell and Margaret Hodge, who visited the Channel Islands, and visited Jersey, they're quite ready for another go at the subject in the near future. And then you get on to international affairs. So the question is really, how much of an international identity does Guernsey and Jersey have? Because obviously it's not a sovereign state. I know Jersey, and it's partly my fault, made a attempt to join UEFA and had the slight problem of not being a sovereign state as a bar to that application being successful. But to a very, very great extent, Jersey and Guernsey have the independence, the constitutional independence that defines a sovereign state, except for the ability to wage war against its neighbours and the simple recognition of it signing treaties by other countries. If you look at the autonomy that the German Constitutional Court says defines state sovereignty, Guernsey and Jersey are there, apart from not having the right to their own army. In actual fact, they have powers that many EU member states don't have over their own laws and powers which actually traditionally define a state. So, the royal charters and relationship with the Crown. Now, we did a lot of this last time, and it's inevitable to do a little bit of it again. Maybe this time, changing the focus, because last time the focus was on, well, why did the Guernsey legal system survive as an autonomous legal system? It's an autonomous system of law, its own customary law base, as opposed to being assimilated into the legal jurisdiction of England and Wales. Here, the focus shifts slightly onto the related topic of the relationship with the Crown, once the Crown became the Crown of England, and then the Crown of England, Wales, Great Britain, Northern Ireland, etc., etc. How did it not ultimately fall under the authority of the British government? So, historically, the Channel Islands were, of course, part of Normandy, which meant that if you were to go to the Fountain of Justice, you had to go to Caen, because that was where they had their Exchequer Court. And the Exchequer was so called because it had a tablecloth which was checkered, and that is why we have a Chancellor of the Exchequer. So if you wish to start civil proceedings, ultimately you would have to go to Caen. Now, of course, the thing is that if you were a peasant, you wouldn't be doing that anyway, because you wouldn't have the money, you wouldn't have anything to litigate over, and you'd just be having to hope that your lord of the manor didn't beat you over the head when you wanted to. So what happens in 1204? Well, the Channel Islands are still meant to be part of Normandy, but the Exchequer Court is now sitting in a territory that's not under the control of the Duke of Normandy as recognised by the Channel Islands. Now, again, we have to just mention that it's not as simple as 1204. There's a whole business of being captured by the French, retaken by a pirate, and ending up back in control of King John. So, where would the Channel Islanders look for justice? Well, there'd be the feudal courts, the manorial courts, essentially the seigneurs. You have seigneurs here. Yeah. So they would be the ones who would have the local jurisdiction over the local peasants, and they would have feudal rights over the land. Then you have the ecclesiastical courts. This would be the Bishop of Coutances, who would be over the water and actually continue to have jurisdiction in ecclesiastical matters until you get to the Reformation, and that breaks the link. The royal court in France, well, obviously no. There is no way that you can go to the King of France if you're in post-communist Guernsey for an order of justice as to resolve a problem in Guernsey, because the King of France actually had no practical authority here because, well, his troops weren't here, to put it simply. So none of those were possible. Now, what you have instead, it is said, are the constitutions of King John. It seems wildly implausible that King John would voluntarily provide anyone with a constitutional document, but there you are. Now, the originals are lost, which quite possibly means that the originals never actually existed. There was a tendency, as I think I mentioned last time, to forge documents in the Middle Ages in order to back up claims done on a grand scale in Italy, when the Pope claimed half of Italy on the basis of a forgery. And very successfully, we held the territory for hundreds and hundreds of years. So this would be, small league stuff in comparison. So they exist now in a return from 1248. And as you see, because I was wondering whether I'd got the date wrong about the warden of the court, warden of Jersey and Guernsey being 1248. I think I got it right in the last day, but it really isn't very important actual date of when warden started to be appointed. But suffice it to say, 1248, there is a copy, or partial copy, of the constitutions of King John. And from our purposes, what matters is the creation of, this dealt with disputes between the islanders and the warden. And that was the reason why the warden produced it. And of course, the warden was often not actually resident. It was, as very often the case. In those days, you would get given a sinecure and then pay for somebody else to do your job for you. So the constitutions of King John, possibly not genuine, but it doesn't matter whether they're genuine or not, because they have been referred to by the Privy Council, and when trying to determine its own authority over the Channel Islands. There's a case of Renov against Attorney General, which was a criminal appeal to the Privy Council from Jersey, and the whole question of whether or not you could have appeals on criminal matters. So the Privy Council was heard there. Was this an appeal that was contrary to the independence of the islands? To which the answer was no, because the Privy Council represents the King, not the British legal system. So what was in the Constitution of King John? Well, we're only interested in two parts. One is the creation of 12 coroners, sworn to keep the pleas and the rights of the crown. So you're creating local officials to keep the law, which obviously means a lack of a need to go off to the fountain of royal justice, which is to be found where the king is based now in Westminster. Similar positions have been created in England in 1195. These are the positions which we now know as the coroners. There's actually a series of detective novels set around a coronator in the times of Richard I and King John. So this was very much a modernising effort, and as happens with modernisation, quite possibly just copying what was done in England, because that provided the precedent. It's quite possible that these offices have now turned into that of jurat, or would do in due course. And the other point was that you didn't have to go for a writ from the king himself in London, unless it was a matter of was half a knight's fee, which basically meant it's sort of the equivalent of, you had to, if something was worth millions and millions of pounds, you might have to go off to London to ask the king for justice. But otherwise, local justice would be dealt with locally. And still not that much of a surprise that it should be possible the king would demand or retain a role, a direct role in such matters, because this is an era where justice was still very much royal justice. The king was still very much, I am the fountain of justice in a personal way. And it wasn't really until the 17th century that the last vestiges of that were knocked on the head, even in England. And the echoes of it are still to be found in the fact that Privy Council's Judicial Committee gives advice to the Crown. It doesn't actually issue a judgment per se. So early administration, usually a warden. Bailiwicks were separated around 1300. Only a single seal was sent by Edward I in 1279. And for those of you who like your medieval history, seals were terribly, terribly important in those days, because that was how somebody who wasn't the king exercised the royal authority. So soon after 1300, you get 2 seals, one for each bailiwick, and and 1315, 2 bailiffs would provide their own seals. If something applies to the whole Channel Islands. Now that's not just background material, really. It's not how exactly you end up with 2 Channel Islands rather than a single unified Channel Island state is not really that important for the purposes of this course. So the historical background is interesting in terms of what we discussed before. It shows the different ways in which the Crown has related to the Channel Islands in this early period when the relationship became settled. And if you recall from last time, you have an ebb and flow. Originally, the kings of England don't recognise their loss of Normandy, at least not officially. So if Henry III rules Guernsey as Duke of Normandy, obviously he's not going to annex Guernsey into the English administration. When subsequently him and Edward I are ruling, paying homage to the King of France for Guernsey, they're not again going to annex. And the only real difficulty, the big sort of crisis point here, was when Edward I, in his customary way, decided that he was too busy crushing other countries to actually want to acknowledge anybody's superiority in any way. And he refuses to pay homage to the kings of France. Whereupon it's actually striking at that particular point that you begin to get the questions asked from Westminster: why do you have these privileges? Why are you different from Lincoln or Grimsby or Wells or somewhere like that? Why do you have your own different set of laws? We have the common laws common to our realm. Why are you different when surely you are part of our realm? That goes away when briefly the kings of England decide to pay homage, then goes away again when the kings of England decide that actually they are the kings of France. So for most of the 450 years after the communes, essentially the Channel Islands autonomy is more or less guaranteed or more or less promoted by the political realities of how the kings of England would have seen the Channel Islands, how they would have used the Channel Islands. Now, some of you might know, Guernsey, Jersey were basically used as Guantanamo Bay substitutes until the 1670s, because the writ of habeas corpus, not being in the common law jurisdiction, didn't actually run to Guernsey and Jersey. So if you were a royal officer, you could hold a political prisoner here, and there's nothing that the courts could do against. That was done away with by the Habeas Corpus Act in the 1670s, which basically meant that if you were the royal officer here, then you'd probably need to stay here for the rest of your life, because if you came back, you would be held in contempt of court. But by that stage, it's actually beginning to move into a much more constitutional period for England and Wales, and the danger points of royal annexation have probably passed. So danger times have said Edward I and II not paying homage, and also the reconquest of Normandy by the Kings of England between 1414 and 1450, which left the Channel Islands a little bit vulnerable, because then the question could be asked, well, why aren't you getting your writs from Caen once more if you're part of the Duke of Normandy? Which is why this funny document called the Precept suddenly turns up in 1441. And this one almost certainly is a forgery, basically saying we're entitled to our independence from Normandy as well as our independence from you. This was all settled a long time ago, that we're just our own jurisdiction. So the Edward III Charter, you don't have to learn the whole charter. The point here, this is 1341. It was a good year for Edward issuing charters, because he wanted to make sure that the country was on his side before he started in earnest with trying to conquer the French. And having been king at the time, at the end, when the challenges to Guernsey and Jersey's constitutional independence was still going on, he's now kind of flip-flopping. This is where he basically says, okay, forget all the quo warrantos, forget all the demands to know about what your privileges are. I recognise your privileges. You are who you are. You're a different jurisdiction. You have rights that are entirely independent from the English courts, and I'm not going to do anything to upset that, particularly as you're sitting off the coast of France, and I'd rather like to keep you in my jurisdiction, because it would be a really bad start to the war to lose parts of France I actually have. So you then get royal charters. Charters will be issued by kings normally when they become king. As you can see, Richard II, it's 1378, that's the year after he became king. Another one, 1394, Richard, if you know your history, had bouts of absolutism and bouts of trying to whinge his way back into the public affections, which finally ended with him being starved to death in a castle. Henry IV, 1400, that's when he's properly become king, because of that. Richard II is now dead. Henry V, just taken over from Henry IV. Henry VI a bit later, but he was a baby when he became king, and he was actually completely and utterly useless. Edward IV, again, two different charters. He had different time. It was coming and going a little bit, because that's the highest of Wars of the Roses. You're getting new privileges being confirmed as you go along. The privilege from taxation and free commerce is the important one to look out for. Henry VII, Charter 1485, obviously he's just taken power. Henry VIII, again, just when he's taken power, largely confirming the current position. It's important not to think that much real care is being taken on the English side as to what they're recognising, that there's any great policy involved. The Channel Islands, by and large, were very much a sideshow for the kings of England, and by the late 15th century, they'd actually been granted neutrality by the Pope, so they weren't even a player in the international games or any wars against France. So if there was a war between England and France, there often was, England couldn't use the Channel Islands as a staging post, and the King of France would face excommunication if he invaded the Channel Islands, which, if you were King of France, was a very, very bad thing, because they very much held themselves up to be the most Catholic, the most Christian, and Spanish were the most Catholic, one or the other. The really important one from our perspective, and it's important because it has citations. It has actually been used, and it shows the continuing political significance of these charters. It sets down the position that was reached over the centuries, and actually, to many extent, the position that existed the centuries prior. to Elizabeth. No excise duties, no taxation from London. The jurisdiction of the Royal Court confirmed. It had been for centuries, but this is a clear restatement. This is still accepted as being the basic ground rule. No writs in the English courts going to Jersey and Guernsey. And again, you'll find that clearly recognised within the case law of the English courts. Decisions of Edward Coke, for example, which I think are in the study guide, and cited in the previous cited in the last session. Now, there's no surrender of the monarch's power to legislate. So the Crown doesn't deny the basic power of the Crown. And that is very, very important, because one of the key issues is going to be, is Guernsey under the Crown or is it under Parliament? We're still, in fact, by this stage, we're beginning to move into the era where the kings and queens of Europe started claiming absolute status. So what Elizabeth is doing here, or rather what our ministers are doing here, is reserving that absolute power. Whilst at the same time observing independence from the machinery of government, which was England's machinery of government. I think that's a good way of looking at it. And it's referred to in the preamble to the Judgments Reciprocal Enforcement Guernsey Law 1957. Some laws have preambles which try and explain why exactly the law is being passed. It's entirely unnecessary to do that. Some laws do. And this one talks about how Guernsey was a separate jurisdiction and how it's going to recognise and enforce judgments from outside in a way that was compatible with that position as a separate jurisdiction. I'm not entirely sure why that preamble was thought necessary, but it's useful to you to know that it was there, and that's an example of continued relevance of the charters. And Jersey's chief minister referred to the charters in the to a House of Lords committee in 2008-2009, and of course, in Brexit discussions, the charters are relevant to show the historic nature, just how much the relationship in terms of taxes and customs duties and the lack of customs duties, how much that is embedded into the constitutional relationship going back centuries. It's not just a right that has been conferred under a Customs and Excise Act 1979. It's something which has existed as being a fundamental part of the relationship going back to all those charters. And that's a much more impressive thing to be able to say. It'd be impressive even if they had to do it in a few years' time to say to the European Union, no, you can't force us to force the UK to impose duties on Channel Islands goods, because that's contrary to the basic constitutional relationship. It's useful to be able to have that sort of material. Now, there are charters up to James II, but charters go out of fashion for a very obvious reason, that after the Glorious Revolution, the whole idea of the royal prerogative being the great power to determine rights and responsibilities essentially dies. The king tried to use his prerogative to set aside laws and to make himself absolute. In actual fact, it's a far closer run thing than people tend to appreciate, because into the 1680s, the declaration by Oxford University about its allegiance to monarchical absolutism. So it could have happened differently, but instead what happens is that in 1689, the prerogative goes out of fashion, or essentially it can't change the law anymore. It can't make law anymore. And all the previous charters are ratified en masse by Parliament. That stops the problem of the Crown trying to revoke charters, because there's a massive pro warranto proceedings in the 1680s to try and disenfranchise various boroughs, and for the Crown to then issue franchises where it suited it, take control of Parliament. So the age of the royal prerogative goes, and what you get instead quite soon afterwards is that the customs elements of those charters becomes incorporated into Acts of Parliament, which happens in the early 18th century. I said there were two dangerous periods. There was a third dangerous period. It was the Commonwealth, because amongst the various attempts that Cromwell made to try and establish a constitutional government was a new constitution where the Isles of Jersey and Guernsey would have sent representatives to London. I think Cromwell wouldn't have had any time for the niceties of Channel Island independence. It would have been quite difficult to conceptualise it, I suppose, from his perspective, because how can you be what they now call a crown peculiar if you don't actually have a crown? Guernsey, I think, was parliamentarian in the war, and Jersey was very much royalist. But it doesn't look like Guernsey got any special favours when it came to maintaining its independence in the 1650s. But here, the Commonwealth is essentially eradicated from official constitutional history. Any act passed in the Commonwealth period was simply treated as non-existent afterwards. No matter how good a law was, if it was passed by Cromwell, it was out. I think they were even quicker at doing that than the Channel Islands were at eradicating any legislation passed during the occupation. So that is the background. Channel Islands have their administrative independence recognised, their judicial independence recognised, but the Crown is still there as the holder of its prerogatives. So, it's now usual to start with the Kilbrandon report. The Kilbrandon report, as I said, was a report, a Royal Commission in the late 60s, early 70s, into the whole of the constitutional position of the United Kingdom and those parts of the British Isles that were allied to it. One of its roles to consider whether any changes are desirable in the constitutional and economic relationships between the Channel Islands and the Isle of Man. So the first time this really begins to try and codify, trying to settle down to clear rules as to when it's constitutional and when it's not constitutional for the United Kingdom to legislate. And by that, it can mean one of two things: for the Crown to legislate by order in council, or for Parliament to legislate by Act of Parliament, or indeed for order in council to bring into effect an Act of Parliament. So it had to decide what was the legitimate role of the Crown, first of all, in respect of Jersey and Guernsey. It said that it had responsibility for good government, which is one of those wonderful phrases that can mean everything and nothing. It doesn't mean good government in the sense that some people would say government would be better, more good, if it was run by conservative people rather than socialist people, or vice versa. It's got nothing to do with the merits of the policies being carried out. It's about whether government is being carried out in a way which is constitutional, systematic, well ordered. As opposed to chaotic, anarchic. But the Crown acts through the Privy Council on the recommendation of UK ministers in their Privy Council capacity. So this again is that technical difference. Why is it always the Privy Council that we talk about? It's because the Privy Council is the council of the monarch. The Privy Council could have become the cabinet for the United Kingdom in the 18th century, but it didn't. So it's a bit like if you're if you're the Home Secretary, you have your Home Secretary of England and Wales hat on, and you're interested in the affairs of England and Wales, and then you would become, in those days, it's not moved to the Ministry of Justice, but if you were then required to exercise any judgment as regards Jersey and Guernsey, you'd put on a different hat. You weren't meant to be following government policy or government interest. So if you were to be signing off on the royal assent for a tax law in Guernsey or Jersey, your question is not, well, is this good for England and Wales? Your question is whether this is actually in good constitutional order for Guernsey. If it was something which would nowadays promote tax avoidance contrary to international standards, you could say no to it. If it was something which allowed for advantages which would see money flow from England to Guernsey, then you still have to say yes to it. That's the basic theory, because you're not interested in the selfish interests of England and Wales. Privy Council's main business is the ratification of laws submitted by the states. And again, they're talking about ratifying by orders in council. They're very much, and it has to be the correct way of seeing it, an order in council that gives effect to a projet de loi, in one sense, is just an order in council, but in reality, it's doing something very different. It's actually giving assent to legislation passed by the appropriate legislature. It's not a despotic act of royal authority in any way. In those days, it was the Home Secretary, who was now the Justice Minister. Justice Secretary? Anyway, I think it's Justice Secretary, is the Privy Councillor primarily concerned with the affairs of the islands. Which basically means that, as Edwina will know, we don't have to talk to every ministry in Westminster by and large. We have one gateway, and within that, we have one phone number, we have one group of people to copy in if we want to talk, and they are the route to getting to talk to anybody else, which is very useful because those everybody else probably comprised of people who think that Jersey and Guernsey are part of the United Kingdom. One of the most intelligent people I know, one who was extremely well schooled in politics, back in 2015 asked me how the general election was going in Jersey. And when I said, well, we're not in the United Kingdom, he said, well, where the hell are you? So there's that level of knowledge of Jersey and Guernsey amongst even very educated people in the United Kingdom. So it is actually extremely useful to have as a point of contact people within the Ministry of Justice who do know their stuff. Key points. The islands are not represented in Parliament. This is a point of fundamental importance. If you are not part of the legislature, then you should not be subject to the rules of a particular organisation. It's recognised in the Matthews case, for example, and we'll get to later, the European Court of Human Rights. So it may be that Jersey, Guernsey, Alderney, Sark, the Isle of Man together would struggle to, well, would probably qualify for 3 constituencies out of what would then be 653. I would not have, normally speaking, the greatest of influence in legislation, but the absence of that vote, the absence of contributing to the common decision making means that decision making should not have any effect here. That is basic democracy. No taxation without representation is true of all laws. I restrain myself from a quick rant against the concept of a soft Brexit on those grounds. Anyway, acts of the United Kingdom, therefore, do not automatically extend to the Channel Islands, and they never have. By convention, the United Kingdom does not legislate for the islands without their consent in matters of taxation or other matters of purely domestic concern. So here you begin to start thinking we're getting a bit onto slippery ground, aren't we? By convention. So what does a convention mean? Does anyone actually know what a convention means? I might write it up here. Anyone know the conditions for something being a constitutional convention? Okay, so this is Mr. Ivor Jennings. Have you heard of Ivor Jennings? So Ivor Jennings is basically of the 2 most important constitutional theorists in the United Kingdom, Ivor Jennings and Dicey, basically. So Ivor Jennings is a critic of Dicey. He was very much on the left side, extremely interested in writings, very, very easy to read. Actually, Dicey is very easy to read, and I heartily recommend reading both of them. Not necessarily for the Channel Islands, but actually just for generally, they're absolutely wonderful. But anyway, so what are the rules for being a constitutional convention? Firstly, compliance. History. You can't have a constitutional convention unless people have actually been complying with it. Stands to reason. You can't just magic something out of thin air and say there will now be a convention to say this, because you don't actually know if anyone's going to do it. Second, compliance out of obligation. It's all very well that people do something an awful lot of times, but are they actually obliged to do it? Are they doing it simply because it's actually what people would do anyway? So you really then get down to this. Obliged for a reason. So simply because you think that something is a good thing, and therefore it's what you do anyway, doesn't make things a constitutional convention. There has to be some big underlying reason for why people do it. Otherwise, you all know that Franklin Roosevelt was the first US president and only US president to have more than 2 terms. Yeah. So the presidency existed for 140 years, and it was said that there was a constitutional convention that no president would stand for more than 2 terms. And it's mentioned by Jennings when he wrote in 1930, no US president could stand for more than 2 terms, and it's just a constitutional convention. And then in 1940, he stands to be president again. And people say, well, that's wrong. And someone says, well, why is it wrong? I'm better than that guy. You prefer me to that guy. What's the reason why I shouldn't? And there is no reason. So the fact there's a long compliance history, the fact that up to a long period of time, people had that sense that you were obliged to stand down after 2 years. Once challenged, the lack of reason meant that it completely disappeared. So you always have to question, what is the reason for compliance by Parliament? Is it acting? It probably acts out of a sense of obligation, because it has that sense of no taxation without representation. There's that basic belief in the heart of democracy that you don't particularly have the right to legislate for somebody who's not represented where you are. But how strong actually is that reason? And that's perhaps the problem that the Channel Islands have and will have in the future. I mean, there have been times which aren't really represented on the books because they were kept largely behind the scenes. For example, when the Tony Blair's government was elected, it decided that it would abolish all formal vestiges of the death penalty throughout the overseas territories, and also require it of the Crown Dependencies. And if the Crown Dependencies, and it would have been really the Isle of Man, had said no, then the UK Parliament would have at least purported to have legislated directly, not with any good democratic underpinnings, but simply because they believed that whatever was the democratic objection to legislation, the objection to the death penalty was greater. So the problem Channel Islands really has, and Guernsey really has potentially, is that the UK's sense of obligation. It certainly doesn't feel a sense of obligation when it can start citing international standards. So here we are, good government. This is the best definition. So it's about breakdown public order or endemic corruption in government, legislature, or judiciary. So becoming like the Turks and Caicos, really. That's the example of this actually being used in an overseas territory. Interestingly, the French government has the treaty right to do something similar as regards to Monaco. It's not that interesting, is it? But anyway, it's interesting to me. And Kilbrandon makes it clear that this is about grave internal disruption. It's not about knowing what's best for somebody else. Now, as we said, under this, and we say it's a convention, that means you have the power, but it's not used. Now, to some extent, historically, Jersey and Guernsey have been caught up with greater international and greater concerns of the UK government. So when in the 1770s, the UK Parliament, and so the Crown, asserted its right to legislate and Parliament's right to legislate without registration in Jersey, is in 1771, which was at the same time, of course, that Parliament was asserting such a right in the American colonies. Parliament asserted such a right in Poynings law as regards the island of Ireland in the 18th century. So it would have been tremendously embarrassing to say, well, we don't have this right to force our will on the Channel Islands because somehow they are different. Although if you look at the history, and history we've gone through lots and lots of times, they are different. They were never conquered, if anything, the other way around. But the UK has always been asserting what's called the paramount power of Parliament to legislate. Dicey said it was clear and obvious, indisputable that this power existed. He was writing at the start of the 20th century. So this brings us to just touch on what happened recently. It was the Sanctions and Anti-Money Laundering Act of 2018. There are certain rather technical issues in this which I wouldn't want to go into around the policing of territorial waters. They're rather technical because, of course, the sort of policing of territorial waters involved would require the Royal Navy. So if Jersey and Guernsey were to do it themselves, there would still need to actually agree to the UK doing it, because quite simply we don't have that sort of firepower on our dredgers and tugboats. But the main thing, as you may recall from the newspapers, was around trying to force a register of beneficial interests. Were you involved, Rena? No, but you remember it. Well, for lots of discussions, and so essentially this was backbench driven, and to a large extent around the breakdown in discipline in the Conservative Party, because a lot of the people who were backing Labour to try and force the Crown dependencies to do this were the same people who get their face in the front of the Daily Telegraph with words mutineers over their mugshots. It's to a large extent propelled by the breakdown of the Conservative Party discipline. Because what should happen in cases like this, and what actually had happened with an amendment put forward by Rupert Huck, Labour MP for Ealing, I think at the start of the Corbyn era, was the Channel Islands talked to the Ministry of Justice, the Ministry of Justice talked to the backbench MP concerned and say, well, there are constitutional conventions that go back centuries. We simply do not have the right to do this. No taxation without representation. They're not actually part of the United Kingdom. You may have missed this and failed to understand the consequences for this. Could you please drop it? And in the past, that was what would have happened. When you have a breakdown of discipline in the governing party, then you no longer have ministers being talked around by officials, able to exert their authority over a majority of MPs. So you then begin to have an open door in which those who talk, like Margaret Hodge, talk endlessly about tax avoidance, despite their own family tax arrangements, to try and walk through. And that was what came very close to happening here. And although the matter was withdrawn as regards the Crown dependencies, those behind the legislation never admitted a lack of constitutionality. They basically put it down to there being complications that couldn't be solved within the time limit. They've had to delay the legislation. It wasn't legislative time in Parliament to have dealt with the difficulties as regards the position of the Crown dependencies. but they did force them, the legislation on the overseas territories. Because there you have a more colonial relationship, and in that the origin of the relationship is one of conquest and total British supremacy, subject to the Constitution's granting. It's very disappointing to see the SNP up there with this, because of course the SNP are fresh from going to the Supreme Court in the UK to say that a constitutional convention that Parliament shouldn't legislate without their consent should be enforceable. So they're the last people to try and challenge the meaning of constitutional conventions that recognise local autonomy, but there you have it. As Andrew Mitchell was one of them, as a Tory MP. He was former International Development Secretary, may or may not have shouted at policemen, and therefore got and therefore turns up on the back benches and has to re-establish his reputation. I suppose anyone could become a cabinet minister next week, so it's good to get your name known. Margaret Hodge is another one, and of course, generally, you have a Labour Party under Jeremy Corbyn, which is much less inclined to observe the niceties of constitutionality if something can progress what they think is politically, economically, socially just by their standards. So I think the point being that the Constitutional Convention looks like it's breaking down at the third stage with many MPs at the moment. Now, there are many early UK acts which applied in the Channel Islands which did not appear to be registered, because what would normally happen is an Act of Parliament would be registered in the Royal Court as a law here, whether it comes via an order in council or comes directly. And so non-registration is a fairly clear sign of direct legislative power. It doesn't involve the Channel Islands at all. It's not the Royal Court saying, yes, we accept that law. It's not even a formal stage there. Although it should be noted that many of these laws were not really regulating internal affairs. In the old days, there was rules that you couldn't export wool from England and Wales to most places. And so this legislation was actually say you could export it to Jersey and Guernsey, but it couldn't be re-exported. It's not really regulating internal affairs about what happens to wool after it gets passed on to the Channel Islands. Now, you also have legislation through prerogative. Now, this really is almost like, as can still exist in some countries, when you have the ability for legislation to be done by executive decree. It's almost like the power of the Weimar president. But it's the civil law commissioners to Jersey, there were no civil law commissioners to Guernsey in 1861, said that it derived from the supreme legislative power possessed by the original Dukes of Normandy. Now, whether the Dukes of Normandy really ever had that power to legislate by decree without consultation of the local good and the great is another matter. It's probably a little anachronistic, assuming that the absolute monarchy model of the 16th and 17th century was actually the true model of monarchy. Now, the sovereign no longer uses this power to legislate directly in Guernsey. It's not without consent. when there are areas such as ecclesiastical law where orders in council are needed for the legislation. And it can appear at times, I think there's an example in Jersey, where one was made, but there's no sign on its face of any consent being given. But in actual fact, it was requested behind the scenes, so it doesn't really count. So on the question of legislation through prerogative, we now have cases. We now get to actual cases, which is good because cases can be cited, they can be read. They can be interesting. Only one of them involves Guernsey. And it's a bit of an oddity because it was largely about letting the office of Contrôle de la Reine, or what's now the Solicitor General Office, Control Office, lapse. Essentially abolishing the office by the expedient of not appointing a new one. Now, the point made by the Privy Council is that this was essentially a legislative act on the sly, and it could only be made by the proper legislative form. And it's also considered, discussed, not decided, because it didn't fall to be decided, those uncertainties whether an order in council, a legislative type, could be passed without consent. I mean, this is the mid-19th century, so certainly as regards the British Isles, you're moving into a much more democratic age. You're looking into an age where people have very much learned the lessons of Boston Tea Party and other such events in the USA. Still not entirely learning them in respect of Ireland, but it's definitely an improvement in terms of general political morality. And what happens in all these cases is something unconstitutional happens. People complain to the Privy Council. The Privy Council says, well, I think this looks like a jolly strange thing. I'm not sure it should be allowed. And maybe it would be better if it was withdrawn, and it gets withdrawn. So you don't get what you really like as a lawyer, which is a nice, clear, found that the orders in council cannot be passed without consent. You don't get that in these cases. You get it clearly being recognised that orders in council shouldn't be passed without consent. But it's a bit like saying, well, the Queen must give assent to legislation without actually saying that the Queen is legally obliged to give consent to legislation. And actually, it might be useful to go back to this to say a few more things about that, which is that if you ask, why does the Queen give consent to legislation? Why is the Queen bound to give consent to what Parliament passes, but the US President can veto legislation and can use that veto? And the answer is because if the Queen decided not to pass legislation, not to give the royal assent, there'd be such a constitutional crisis, there would be a tussle for power that the Queen could only lose in the United Kingdom, resulting in her removal. Just as when the House of Lords in the Edwardian days decided to go against convention and purport to veto a reform in the budget, it had been pointed out a few years before by Sidney Lowe that if they ever did such a thing, they would lose the power struggle, and lo and behold, they had their veto power taken away from them. So the interesting issue in Jersey and Guernsey is that whilst it's being recognised that it's unconstitutional for the UK to pass orders in council in this way, and also, and by extension, we might say to refuse orders in council where a projet de loi is passed, what is the actual sanction on the UK? What is the tussle for power that the UK might lose, equivalent to what the Queen would lose if she ever challenged the prerogatives of Parliament? Does that make sense? So you can see that the reasons for the obligation to carry it out when viewed from a cynical UK perspective are not necessarily that great. The States of Jersey case is one of these cases to do with the Privy Council making orders to do with the organisation of the police in Jersey. And you might ask, why on earth are they doing this? And it's probably because Jersey had been a bit of a nuisance to them and somebody had asked them to pass these orders. And you've got a bit of an in-out negotiation as the Privy Council recalls orders made by the Privy Council earlier, and then a discussion as to what orders should take their place. Another case to do with Victoria College. Victoria College is just a school, and I have no idea why exactly the Privy Council should be involving itself in the government of Victoria College, unless, as I say, Jersey was making a nuisance of itself, and some people were trotting off to the Privy Council saying these people are running themselves really badly. Would it? Actually, would it help to just have a quick break then? Okay.